Hi everyone, welcome to the fifth lecture of Company Administration. Here in this session, I am going to deal with the various types of companies on the basis of number of members. On the basis of number of members, the companies are classified into two, that is, private company and public company. What do you mean by a private company? As per Companies Act 2013, we have a definition for private company. That is, Section 2, Subsection 28 of Companies Act define a private company as a company which has some restrictions on its articles of association. Its articles of association restricts the transferability of shares, and also it restricts the invitation to public to subscribe its shares. In short, we can say that a private company is a company which has some restrictions in the articles of association regarding invitation to public to subscribe its shares and transferability of shares. Listen once more. As per Section 2, Subsection 28 of Companies Act 2013, the private company is defined as a company which has some restrictions in the Articles of Association regarding transferability of shares and restrictions in inviting public to subscribe its shares or debentures. The Articles of Association impose the following restrictions for a private company. There are mainly four restrictions. Number one is it restricts the transferability of shares. Second one is it limits the number of members, that is, it limits the maximum number of members to 200, and it prohibits the invitation. It prohibits any invitation to public to subscribe its shares or debentures. And fourth one is it prohibits the invitation or acceptance of public deposits. Once more, there are mainly four restrictions. Number one is it restricts the right to transfer the shares. And second one, it limits the maximum number of members to 200. And third one, it prohibits the invitation to public for subscription, for subscribing its shares or debentures. And also it prohibits the invitation or acceptance of public deposits. A private company can accept deposit from its members, directors or relatives, but they can't accept any deposit from the public. In short, a private company is a company has some restrictions in the Articles of Association, especially regarding the transferability of its shares, and also in the case of inviting public to subscribe its shares or debentures. This is what do you mean by a public company? A company which is not a private company is known as a public company. That means the Articles of Association of a public company do not have any restrictions regarding the transferability of shares or invitation to public to subscribe its shares or debentures. Okay, listen once more. On the basis of number of members, the companies are classified into two, private company and public company. Private company have some restrictions and public company don't have that much restrictions. Private company have mainly four restrictions in the Articles of Association. Number one is it restricts the transferability of shares. It limits the members to maximum number of members to 200. It prohibits the invitation to public to subscribe its shares or debentures. It also prohibits the public deposit. It also prohibits the collection of public deposits. And a public company is a company which do not have any type of restriction in the case of transferability of shares or invitation to public to subscribe its shares or debentures. Okay students, this is all for this session. Post the assignment before July 2nd, 2020. Stay safe at home. Thank you.